Hi, I'm Tom Rauchegger and I'm here with Scott Cramer, and we're coming to you today from the offices of Cramer Rauchegger in Maitland, Florida. Today's discussion is going to revolve around estate planning, and specifically the difference between a will and a living trust. There's really two main reasons people do estate planning. Number one, they care about someone more than they care about themselves. And number two, in some instances, they hate paying taxes. Scott, why don't you tell us a little bit about estate planning today?
Yeah, perfect. Thanks, Tom. Quick disclosure, Tom and I are not attorneys. We're not giving legal advice. If you need legal advice, please consult your attorney. So there's a lot of confusion around estate planning. What is a will? What is probate? How do you avoid probate? What's a trust? Is there costs involved, and what are the advantages? We're going to go through all of that here today. So a will is a document with instructions on what happens to your stuff, your estate, after you passed away. A will is necessarily, by definition, settled through the process of probate. Probate is a court process. The will is submitted to a court. You usually have to hire an attorney, and it takes somewhere, in the state of Florida, the average is around 3 years. The cost of probate is expensive. All of the fees are not attorney's fees, but there's different fees that involve, but usually the state of Florida, the average cost of settling estate is 6% of your gross assets. So add up everything that you own. Don't worry about the debt, because you don't get to subtract it off as for the purposes of cost, and multiply it by 0.6. It can get expensive. Most people who have an estate plan, they want a couple of things to happen. They want to make sure that all of their stuff goes exactly to who they want it to go to, under all circumstances, with the least amount of expenses and the least amount of taxes. So the least amount of expenses is how to avoid probate. You can create a revocable living trust. A revocable living trust avoids the probate process. Inside the living trust, you have instructions on what happens to all of your stuff under all circumstances, meaning that if you leave it to somebody and they pass away, what happens to that person's share? Does it go to their children, to their spouse, or back into the pot to be divided among the remaining beneficiaries? In addition, with the trust, you can help your assets avoid creditors and lawsuits of your heirs. So the cost of settling a trust is significantly less than the process of probate. You don't necessarily have to hire an attorney or hire somebody like Tom and me who can help you settle the estate. Your trustee can do that himself, or choose to hire somebody like Tom and I to help them. So the advantages of a trust are they avoid probate, it's less costly, and you can usually settle the trust within months versus years versus a will. Tom?
Thanks, Scott. That was great information. A lot of times people say, oh gosh, I've really been meaning to do that, put an estate plan into place and get these documents. The good news is you're watching this video today and you're still here. So the best time for you may be today. So seek out an estate planning attorney or an advisor to get more information, or you can go to our website, www.cramerandrauchegger.com. Thank you.
Thank you.